Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. Friends, welcome back. This is more or less a continuation of what we did in the previous episode, where Jim Desmond is just going to take some frequently asked questions. These are questions that you've been sent or emailed or text over the last few months here as we've done these podcasts and just your normal practice where people just raise questions. And we have a guest in the office today. Colleen's got a few other questions that she may chime in with. So if you hear a new voice on the mic today, that's Colleen, and she's a college student. So, Colleen, as we were prepping for this, you had a question that came up, and we thought, hey, we'll save that for the episode. So why don't you go ahead and ask that, and we'll jump right in.
Yeah, so I had a big question on if texting and driving ever came in play, especially when it came to insurance and, what kind of issues come along with when an accident is involved in texting and driving.
Well, what you're hitting at, Colleen, is the issue of fault. So, in other words, Kentucky is what you call pure comparative fault, which means, again, you can be, 5% at fault for, let me go this other way with it. You can be 95% at fault for an accident and still recover 5% of your damages, okay? Indiana's modified comparative fault. You can't be more at fault than the other person to still have a personal injury claim. If you are accused of texting and driving and they can show that, it goes to the issue of fault because, again, it's never usually clear-cut. The problem is, how did the accident happen? Well, now you're saying, hey, I was texting. Clearly, I wasn't paying attention, and that's, part of the reason the accident happened. And people think, well, the other guy ran the red light, and that's so it shouldn't be coming into play. The problem is, go back to Kentucky being pure comparative fault. I've seen a lot of people, what they do is they say, okay, yeah, he may have ran the red light, but were you speeding, or when did you see them, or why didn't you react this way? Well, all those issues can be used against you as, a percentage of fault. They say, well, you're 20% at fault for the wreck. You can't recover 20% of your damages, okay? So, again, if you're texting and somebody, even if it should be a clear-cut situation, and somebody says, well, but for her texting, we could have, that accident could have been avoided, and we can tell that because the car got mostly through the intersection and everything else. Then now all of a sudden you've given them basically a nice, hammer to swing in your direction to basically push your personal injury claim down as well as your property damage claim down.
Well, and that's a question that you have gotten a few times, obviously, is somebody who says, I want to save on the attorney fee, so, is it okay not to hire an attorney? And especially in a situation like this, you may be giving up stuff that you're not even aware of.
Yeah, and then, okay, not hiring an attorney, I used to say it was like, selling your own house as a realtor, okay, that yes, you could do it, but a realtor is going to do a better job quicker. It's gotten complicated enough that I kind of say, look, hire an attorney. It's worth it. Because not only do you have, right off the bat, you have the senior adjusters will handle the claim if the personal injury attorneys are involved, okay? So you have a more experienced adjuster. You have somebody who probably wants to get the claim done. They're not making some of these same arguments. I see that more often with somebody before I've gotten involved where they try to argue, 20% here or 10%, something like that. And you're like, okay, really?
It's a lot of wasted time, which means wasted time for your client as well.
Well, again, remember why I said, why do people come to an attorney? It's because of how they were treated by the insurance company. If the insurance company would treat people differently right off the bat, okay, then they wouldn't call us. They don't want to spend the money on it and everything else. So I get it. But do I think personal injury attorneys are worth it anymore? Yes. Do I think big firms that treat you like a puppy mill, for lack of a better word, are worth it? No, because again, they have these big advertising budgets and they're trying to get, your case done and move on versus I think anytime you hire an attorney, you find somebody who does just one area or preferably very few areas, and that you're going to deal with directly and not a case manager, not a paralegal, not a secretary. You've heard me preach about that 5,000 times, Jim, where I just think that's the biggest insane situation whatsoever. So,
well, let me ask you this. You just said somebody who kind of focused their practice in certain areas of law, such as injury law. Do you handle things outside of just car wrecks? Do you handle more than just car wrecks?
no, I'm lazy. I don't want to learn a new area. And that sounds like a joke, but it's not. It's true. I mean, I've done car wrecks, basically from the majority of my career,
right.
And I don't want to learn anything else.
Right.
Okay,
you'll get involved obviously with motorcycle accidents. These are motor vehicle accidents. We're really
and I mean, we tease and say that, but I had dinner with a good friend of mine, Joe Pepper, last night, and he does a lot of premises liability. Well, he's 20 times better at that kind of case than I am, so why wouldn't I just throw that case to him instead and let him handle it? I mean, there's just a lot of people I know that do certain things better. I think, again, we talked about this even beforehand. I think one of the best things you can do as an attorney is, to master one trade and not be a jack of all trades. So that's why I'd actually do stick with just car wrecks.
Well, and a lot of this has to do with counseling your client and helping them understand the overall process. Again, the legal process, and especially when there's money on the line, is really complicated, I would think, and it's probably emotional to a point. And there are a lot of questions that come up, and this is one that.
Let me stop you right there because I want to address what you just said. That's the thing, because you go back to what you said earlier, which, is like, okay, well, why should we use our own car insurance? Okay.
Right.
That's the whole thing about motor vehicle law. There's a lot of it that, the law endeavors to make sense, but it doesn't succeed. So again, it's contrary to what the average person would think. So again, go back to why do I complain so much about big firms and case managers and all this other stuff? Because you want your client to not only build that trust with you, but to understand what's going on. And when they do that process together, then, okay, you get an offer on the table that's not the best. But then at least they understand, the strength or weaknesses of the case. They trust you if you say no. Matter of fact, if it might be a good offer, they do trust you and say, listen to their friend that says, oh, so-and-so got me $25,000 when that really didn't happen. So again, I think, yes, that client rapport is huge because motor vehicle law endeavors to make sense. It doesn't make complete sense. The Motor Vehicle Act got passed in, I think it was 76. And again, that was this $25,000 limit we set up was established back then.
And that's the state minimum in Kentucky.
Yeah, we're coming up on 50 years, and we have not said people should have more insurance than what they should have had 50 years ago. That's
Even though
insane.
things cost a little bit more now, and the medical treatment costs a little bit more.
Well, and property damage alone. Remember, in property damage in Kentucky, you can have as little as $10,000 in damage coverage. $10,000 of insurance coverage for the vehicle. So in other words, you hit a Mercedes. Okay, and nobody's hurt, but you hit the Mercedes and it's $35,000 worth of damage. That other person, the coverage might be up to $10,000 only. So now again, you're forced to have that collision coverage instead of the Mercedes.
Right.
So
well, that's interesting. Will my insurance rates go up if I'm using my own car insurance? I think what you were just talking about is an underinsured situation where the driver had some coverage, but it wasn't enough to make you whole.
Yeah, I wouldn't say underinsured because I switched to property damage. I got confused in there.
Okay. So it's a different kind of situation.
But I get that question asked a lot. Will the rates go up? And I've never gotten a completely straight answer from the insurance people I've talked to. Okay, there is a statute that says your rates are not supposed to go up if you're not at fault. Okay, so the answer is no, they should not. Now, that being said, am I going to tell my clients that no, they won't go up? Or am I going to guarantee it? No, because they can find some other reason to raise them.
Well, and that's the thing. There's other factors involved. Suddenly, your teenage driver passes the driver's license. Well, yeah, obviously your rates are going to go up, but it's not necessarily going to be related to that issue. They're going to find other ways.
Right, and the bigger thing is you have to use it. Okay, let me go back to the daughter. I'm going to pick on her on this one because she was actually went 4 years without an accident, but then had 2 accidents within 3 weeks of each other. First one wasn't her fault. Okay,
right. Did she hire you?
I'm pro bono right now. But the short story is the first one, we used the no-fault coverage to cover her medical bills. Right. Okay, they're not significant, luckily, but it's there. The second one, though, I think this is another good reason people need to understand. And, even as a personal injury attorney, do I like to be in this position? No. But the second one was her fault. Okay. Now, I've turned that over to my insurance company. Okay. I know from before I have a lot of insurance, okay? I think the gentleman's not that badly injured, luckily, but I just turned it over to him and said, handle it. Now, 3-4 months from now, they'll give me an update or I'll ask for an update. But it's one of those, I don't have to be involved. Again, it buys me that peace of mind. Now, let's say they can't get that claim settled. Again, that's another advantage of having insurance is if, let's say, she gets sued over this. my insurance company is going to hire that defense counsel to defend her, and I'm not going to have to pay any attorney fees whatsoever. Okay, so do I like using it? No. Are my rates probably going to go up from it? Yes. This is the first time I've used it in 20 years. So you know what? I've got to do what I got to do and just, take the hit. And that's why I have it. I have it so that we're all protected.
Well, you had said earlier about the relationship with a client and how when it comes to accepting the offer, they're going to know, is it a good offer, a bad offer? Are there holes in the case that they need to be aware of or not? Because you've worked with them directly. This is an interesting question. You may have to explain this a little bit. Someone asked, I didn't know I was signing a release. Can I get around it? How does a release? What is a release? How does that impact their case?
A release, okay. For me as a personal injury attorney, a release comes in when we've settled and said, okay, your claim's worth $8,000. The client says, yeah, I agree. And the insurance company sends me the $8,000 check with the release, and the release is that they're signing and the claim's going away. It's barred. It's done. As I always tell people, you go back to the doctor tomorrow. It doesn't matter if you go blind in your right eye. We signed a release. There's no way to recover anything further. It doesn't matter when it's discovered. The part that was getting at, though, the question was somebody had, before they hired an attorney, okay, insurance company approaches them and says, you're right, our guy's at fault. You don't seem like you're badly injured. We're going to pay you $1,200 or something, or $1,000 or $500, whatever it might be, to settle your claim. Okay. If they sign that release, can they get around it? No, it's a contract. Okay. Offer, acceptance, consideration. Those are your three elements of a contract. That's what you've got. Okay. So that's the problem is the insurance company wants to have you sign that release because why? They want to close the claim. They want to go on to the next claim. They want to limit the exposure of their insured. Okay. Do you want to do that? No, because again, you could have a case worth a lot more. I'll tell you about a real interesting one for a second because it involved litigation and I can pull it all together. And it was not one of my cases, but I'm familiar with it.
Sure.
The short story is, firm had a chance. The client injured his hand or finger, okay? And the claim could have been settled for, if I remember right, the offer was $1,500, or the demand was $1,500, and the offer was $1,250, okay? Insurance company refused to accept it, or the client refused to, accept it, okay? And the insurance company refused to go up that $250. Short story, case went to litigation.
Wow.
Guy needed hand surgery, ends up having, I think, $20,000 in bills from the hand surgery. Okay. Goes to a settlement conference, still can't get done. Okay. The figures were much higher at that point. You were $20,000 or $30,000 was on the table. We went, or not we, but the other person I know went to a jury trial. They got over $200,000 in that case. Okay, does that happen very often? No. Even the plaintiff's attorney that I know said, that was the first time in his career that ever happened. But that kind of illustrates again the risks you have and why you don't necessarily jump to, okay, I'm going to settle this claim because you don't know what else is going to happen. And if you need a surgery down the road, then again, you want to be able to recover for that.
Right. Well, this is kind of a related question, and it dovetails right with what you're just talking about. Someone asked, the insurance company just sent me some papers. Should I sign them? You may not know that's a release. You may not know what you're signing. I mean, how do you approach that?
With my clients, I always tell them either one. All right. With my clients, there's two ways to do it. I tell them, one, you can send me a text, a picture of it by text, or two, sign whatever you want to sign, but send everything to me. Because if I don't like it, it's just going to be thrown in the trash. Or if I need it down the road, I'll save it. But also we don't have insurance companies saying, well, we didn't get a copy of this or that because, again, I have it saved to the cloud, so I can always send another copy. For individuals, it all depends upon, what it is. I mean, that's just it. Who's the insurance company? If it's your company and they're sending you a no-fault application, that's fine. It's pretty much a medical authorization so they can get your medical records to pay your bills.
Right.
If it's a release, you're releasing the whole claim. If it's a property damage only release, then it would be okay if you're settling your car stuff. But you wouldn't want it to say medical bills and, pain and suffering. So that's one of those, I would say, be very careful.
Well, I would think this is like anything that you're going to sign. There's always fine print, and a lot of times we don't take time to read through the pages and pages and pages of fine print. If you've hired an attorney, if you've got an attorney, give it to them. You guys read that stuff every day.
Yeah.
You know what to look for. And by the way, that's part of what you're going to, use as your fee to, that's part of what they're paying for is your ability to understand what's on that paper.
Right. And I would say,
explain it.
I would be surprised if any attorney doesn't do exactly what I said in the beginning, which was, fill it out the best you can, send it to them. Don't send it anywhere else.
Yeah.
If they don't like it, they're not going to send it on. Because the other thing on a release, since I'll go on a tangent for a second, remember we talked about this before in the podcast, you got to be careful about what you're releasing and what you're including. Because, okay, our phrase is exclusive of the no-fault lien. Okay, so if I settle, back to that example we said in another podcast where, let's say you get a $7,000 personal injury settlement and your insurance company paid $5,000 in medical bills, okay? You're not going to ever see the $5,000. Your insurance company is going to come along in the back end and say to that other company, we want our money back. So how we say that in the release is we're settling for $7,000 exclusive of the no-fault lien, meaning that fault insurance company has got to address that PIP subrogation, that no-fault subrogation claim from my insurance company. Okay, that's fine. Well, if the no-fault is exhausted, those excess medical bills, those unpaid medical bills are included. Or if the health insurance lien hasn't been addressed, again, that's included. Because most of the time a release says exclusive of the no-fault lien and inclusive of all other claims, including any derivative subrogation claims or liens. And what they're saying is you got a Medicare lien because they paid something, a Medicaid lien, a health insurance claim, they get their money back, part of that settlement.
Well, and again, that's why I am so hesitant to sign those kind of papers. Because, again, I don't fully understand the ramifications of what I'm signing. And if I've got an attorney, I'm going to send that to him or her and say, look, read this and explain it to me. What am I literally signing here? And I think that's what you're really good at because you do take the calls on your cell phone. You make time for the client. And that just, look, if I'm confused or have a question, you would generally take the time to answer that. And that's what makes you a little different at times from, some of these other things where I'm shoved off to a case manager or I'm shoved off, to someone else. I'm talking to an attorney, and I'd like what the attorney knows to be explained to me.
Well, and that's the thing. It's and I appreciate that, but that's back to the issue of I lost my thought when I was listening to you. You go on to the next question. I lost my thought.
Well, you had said one of the things, if you were to sign that and send it in, the insurance company may say, well, we never got that document. Maybe we don't know if you signed. Let me flip that around. Somebody asked, I was sued, but I never received a summons.
Oh, yeah, that's
a little different. Okay, let's unpack that one for a little bit. Okay.
That's a good one because that comes up all the time. All right, and luckily it doesn't come up for my clients, but it comes up for friends of friends, and that they'll send somebody over and they'll be like, "This is what happened." If you get served with a subpoena, you're usually being called as a witness. If you get served with a summons, you're being sued.
Big difference.
Big difference, okay? And a summons is going to usually come to you either by certified mail or by the sheriff, all right? What people don't understand, and usually it's going to have a complaint attached with it, and that complaint is what gets the lawsuit started. What people don't understand is there's not going to be any court date or anything else assigned. They think, I don't have to do anything. There'll be a court date. It'll notify me. No, okay?
Wow.
You've got to file a written answer. If you read that summons, and a lot of people don't, you've got to file a written answer in the proper court, okay, basically responding to that complaint. An attorney knows how to do it. We call it just, legally the term is an answer is what we call it. Even if it's an informal one, you want to be able to do it, okay? Because if you don't, they move for what you call a default judgment, which says, okay, we don't have to get to a jury or anything else. Everything I said in my complaint's true. Judge, just give us the judgment. And when they do that, the problem is now they have an ability to kind of, the judgment, they have the ability to collect against you, whether it's bank garnishment, whether it's pulling a driver's license from a motor vehicle accident, which that can be done when you don't have insurance. That's when you see that.
Right.
But the short story is everybody wants to say, well, I didn't get served with a summons, and they all of a sudden got this notice, they got a judgment. And that's the problem you run into, because 90% of the time they did get served with it. And the other issue you have is, again, if you have a default judgment against you, okay, let me use you as a guinea pig, Jim.
Sure.
So you're in a car accident, okay, you violated the law, you didn't have car insurance, and even the other guy wasn't badly hurt, but he had Ohio casualty and they paid out $3,000 in property damage. They sue you 8 months from now, and you don't respond. You get that summons and you don't respond to it, okay? Another 3 months go by, they've done enough steps that they get a default judgment. Then after they get that default judgment, 90 days after that, they can pull your driver's license. Kentucky says we can pull your driver's license 90 days after the entry of a judgment related to a motor vehicle accident that was not satisfied. In other words, paid. Okay? So now you've lost your driver's license as well. And so now you come to an attorney, and I don't generally do these kind of cases, but still, you come to an attorney, and your first thing is, well, do we want to spend the money to set aside the default judgment? Okay, because we can spend legal fees and try to get this judge to set it aside, but what's the underlying claim? Is it worth it? Did you rear end somebody? Were you at fault? Can we prove you weren't at fault? Can we argue damages? There's a lot of things that go into it, but the initial question you said about a summons is if you get served with a summons, you are being sued, okay? If you have car insurance at the time and it's a car accident, then best thing you can do is immediately contact your insurance company. Tell them if they don't already have a claim, make sure they open a claim, make sure they assign defense counsel, go from there. If you don't have car insurance, then what I'll do is I'll tell a lot of people, call me, and I'll at least give them, 10 minutes of advice and such like that, because you're being sued. But yes, that's the thing is if you get a summons, you are being sued, and you have no choice but to file a written answer, or otherwise you're letting them win by default.
Wow. Well, okay, so this is along those lines, but it is different. Someone asked, if I have 2 years to file my injury claim, if you want to explain what the 2 years is in a minute.
Sure.
If I have 2 years to file my injury claim, can I just contact you a couple of months from now?
No. Okay. Well, yes, you can. You can. Do I recommend it? No.
Okay.
The 2 years is a statute of limitations. Every legal action out there, every legal cause of action has a statute of limitations, okay? Slip and fall in Kentucky is 1 year, okay? Car wrecks are 2 years, and they can be extended, but I don't like to talk to my clients about that. A statute of limitations says if it's not filed within the proper court, within the proper amount of time, it's barred like it never existed. So, you lose your left arm in a car wreck, and you don't file, car accident's a bad example, but okay, you go 3 years in that example, chances are it's barred, okay? The car wreck was a bad example because Indiana, for example, statute of limitations for a car wreck in Indiana is 2 years from the date of accident, period, no extension. In Kentucky, the actual statute of limitations for a car wreck is 2 years from the date of accident or 2 years from the date of the last no-fault payment, okay? So it can be extended. And that's what
a little bit of wiggle room, but again, waiting months and months and months to actually contact an attorney about this claim is probably not.
Well, and that's where we got to get back to what your original question is. Remember, you're building your claim from day one. I always tell people that, a personal injury claim and the medical records and bills that support it is like the Hansel and Gretel breadcrumb trail, okay? That's what you want your medical records to make, in the long run, is that little breadcrumb trail. Because that's probably what you're going through. I mean, if it's not in the medical records, it doesn't exist. So what happens is you wait 6 months, you go to an emergency room, you go to a chiropractor, you wait another 6 months for further treatment because you say, well, it's not helping. It looks like you weren't hurting for 6 months. The common understanding among basically defense counsel, insurance adjusters, everyone is if you're hurting, you will get medical treatment.
Exactly.
Okay. So can someone legally wait up to 2 years and contact an attorney? Yes. And I'll come back to that in a second. Should they? No. You're going to pay that same 1/3 fee or above. Why not get them involved early on? Let them, do what they're supposed to do.
I know in some of these larger accidents in particular, when you have to bring in people to reconstruct the accident, you've got all these other things going on. Evidence can get lost. Evidence goes skid marks on a road. Eventually wear away. The rain and everything else washes it away. All that valuable evidence that may actually prove your case for you, and you've waited 2 years to even think about gathering that evidence or collecting that evidence, is gone now. So you've actually hurt your claim, I would think.
Yes, exactly. I've had cases before, that, when you brought that up, I thought of one 15 years back, but it was who crossed the center line.
Yeah.
And, I was working for somebody else at the time, so it was longer than 15 years when I think about it. But I got authority to spend the money on an expert right off the bat and get him out there. And that's why, because he could tell, from the divots in the road who actually did cross the center line. And that made the world of difference. That's why we succeeded in that case. Recently, I used that same expert, because I've kept a relationship with him over the years, on a case where it was worth it to send him out there. And he looked at it. We didn't find anything, but at least I know that, and I have a better understanding of, what what happened in that intersection. And he does too if I have to call him down the road, if it goes to litigation. If we don't know if that one's going to go that way. So, yeah, absolutely. You're preserving evidence. That's the biggest thing. You got to act like, from day one, this is what happens. I don't know why. I was thinking I'll throw you one, too, that I always stress to people. Because back to my poor daughter. Okay. first wreck, she calls me. She is, very emotional. I won't say hysterical, but very emotional.
Yeah.
So when you're at the accident scene, by the way, and this goes back, that's why I was thinking that, because of the preserving evidence. The first step, calm down. Best thing you can do, take out these video cameras, okay? And
your cell phone, your iPhone, your Android, whatever.
And if you're badly hurt, I understand you can't do it.
Sure.
Okay, but if you're at the point where you can walk around or anything, before the cars are moved, take a photo of them. Okay, if you see a skid mark, take a photograph. Any of that kind of stuff before somebody comes in and contaminates that. Fantastic, because yes, you want to calm down at the scene. You want to give the police officer whatever information you can, and take a look around and see. Because again, if you see that friend that we mentioned that was in a car wreck,
mm-hmm.
okay?
Mm-hmm.
Just because I had to help him get his car away from the accident scene, I went down there, but I walked that area and I found a Ring camera. Now, unfortunately, it did not capture the accident. But had it captured it, it might have turned things around.
Right.
So, again, it's one of those that, the preserving of evidence, I love photographs. I always tell people, cuts or bruises, take photographs, make sure you're going to be comfortable with me forwarding it on to an insurance company down the road. I don't want to see anyone's privates or anything like that.
Cover yourself up where you can. But if you've got a gash on your leg or something
it's worth 1,000 words, as they say. Think about it. If you're in front of a jury 18 months from now and you show, a bloody gash down your leg, as you just mentioned, that's worth more than saying, well, my leg hurt.
Because there's a good chance that's actually healed or the bruise has gone away or something else.
And people understand photographs. Yeah. They don't, words, sometimes we pay attention to words, sometimes we don't. But everybody understands a photograph. And,
Well, in that, being proactive in your cases, that's a great point, because a lot of people assume, well, the police officer showed up and he filled out or she filled out an accident report. They did this police report right there at the scene. Can I use that in trial?
No.
And explain that. That surprises people.
Yeah, the police report's hearsay. Okay, it's somebody else saying something and offering it as the truth. Okay,
because they weren't there at the time.
They weren't there, exactly. So can you use a skid mark? And they say I did a measurement and it's 25 feet long. Yes. But as for the conclusion as to who's at fault, no. Now, does it weigh in heavily? Absolutely. So in the sense, not at trial, but if you have a police report and you're going to an insurance company and they can't get hold of their person, and you got a police report saying that this is what he observed, yeah, it's great. It's it's very good evidence at that time. Is it actually evidence that's going to come into trial in front of a judge? No. Okay.
So in pre-litigation, where you and the other insurance companies are going back and forth, you can absolutely use it, but it's just not admissible as evidence in court. Is that correct?
Yeah. But it's hugely beneficial, though. Yeah. If you can get the police aren't coming for every accident anymore, unfortunately, because of the virus. But if you can get that information, it's hugely beneficial, because, like, I had one again the other day that, again, no insurance listed, so I had to run the plate, okay, to try to track it down that way with the county clerk. But it's a great little benefit, because you have your potential defendants information, the make of the vehicle and everything else. Yeah. But you don't want to always take a chance that everything's in there. The one case I told you that took about a year, that we finally tracked down the car dealership insurance. That was a lousy police investigation. There's no way around it. I could have gotten that done a lot sooner, but it was a situation where it wasn't clear whose car it was. It was in the process of being transferred. The police officer, honestly, he kind of put my guy at fault from minute one. Okay. Wow. And that really went against us, where I had to kind of combat that, but it also showed why I didn't know where all the insurance was, because, again, he didn't really understand the situation. So, and am I negative about police? No, I'm not saying that. I'm not getting that. I'm just saying you can't rely on anyone to, have all the information. So when you're in an accident scene, again, somebody comes up to you, well, hey, were you okay? If you're okay enough to say, were you a witness? Okay, well, would you mind giving me your name and number real quick?
Yeah.
And that's just because, again, the police officers, they do a good job with accidents. I'm not saying they don't. But in the same respect, you don't know, is that person still going to be around? Is this going to happen?
Right.
I had a case, a little interesting side note, as a witness, where I was behind somebody, and they pulled out from the stop sign, and a truck hit them, and the truck overturned and everything. And I stayed around and gave the police officer my card, and I said, I saw this is what happened, blah, blah, blah. Well, again, even though it was pretty dang clear cut, the damages were big enough, and I knew they'd adjust her anyways. But she contacted me and said, hey, can I meet with you? And so we did a little 20-minute recorded statement, 2 months after this all happened, because, again, they couldn't believe certain facts, because the damages were that big from the car wreck.
Right.
But, and again, because I'm a plaintiff's attorney and I saw it and I know exactly, that helped the person that was injured immensely. Do I know the person who was injured? Did I know his attorney? No. I was purely a witness. But again, that made a huge difference for something that should have been, to me, it was clear cut. I could have left that scene and I would never have thought somebody would question liability on that car wreck.
Right. But it happens.
Yeah.
Well, Jim, this has been kind of a frequently asked questions segment, and the previous episode we kind of did the same. Let me wrap up with this one, because this doesn't really fit into the normal conversation, but it is absolutely relevant for people. And we'll wrap up with this question. I owe back child support. How does that affect my personal injury claim?
You still have a personal injury claim. The child support division has a lien against your case where they can say, hey, however much you owe, they're entitled to it. They usually will recognize attorney fees and unpaid medical bills. So if you got a $10,000 settlement and you owe $2,000, it's not a huge issue. It's another thing coming out of your settlement. If you owe $15,000, then they're going to take the vast majority of that $10,000.
Right. So that they will come and get that, and there's really not much you can do about that.
There's nothing we can do. They assert a lien directly against us, which basically said if we ignore us being an attorney, if we ignored it, okay, then, or the insurance company ignored it, we would have to pay it.
Right.
So the only what I do on that usually is I'll see what my unpaid medicals are. I'll try to negotiate where I can with the child support division, see if there's certain extenuating circumstances. You do what you can to still see if your client can get anything from it. It's a case by case basis. It's not where you want to be.
Right. So. No, I saved that one for last because, again, it didn't really fit into the flow of the conversations we've been having. But it's a question that comes up from time to time, and it's something that people need to know about. Jim, that's a wrap for this episode. I appreciate your time. Thanks for sharing your thoughts on this stuff. You've done this for a lot of years, and you've seen a lot of different cases. It's been really interesting to kind of watch how these things unfold. Any parting words as we wrap up this episode?
No, other than, again, the thing is, before you ever get behind a vehicle, that uninsured and underinsured coverage. And if you have any questions, holler. If people can reach me directly, of course, on my cell phone. It's 502-609-7657. If you want to, that you can call or text me. It doesn't make a difference to me.
Good deal, buddy. I appreciate your time. Well done, and we'll talk again in about 2 weeks.
Sounds good.
Take care. Bye-bye. That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky. Until then, check out AttorneyDesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely, and please remember to buckle up.